I'm Steven Casiere. I'm one of the magistrates here at Lucas County Probate Court. So guardianship is a process by which someone applies and is appointed by the probate court to care for and make decisions for either an incompetent adult or a minor. Today I'm just going to focus on an incompetent adult. The person who's under guardianship, the legal term for them is a ward, and the person who is appointed by the probate court is called the guardian. So guardianship of the person is, most of our guardianships are just guardianship of the person. It authorizes the guardian to make placement decisions for the ward, to make medical decisions for the ward, and it authorizes them to provide, or authorizes services to the service provider. Importantly, a guardian of the person could also apply to Social Security to be the ward's payee as well. Guardian of the estate authorizes the person to manage a ward's finances or assets. So if a ward owns real estate, owns a business, has an investment account, any asset or investment activity that needs to be managed, a guardian of the estate could do that. Now the guardian of the estate, there's a lot more stringent requirements on a guardian of the person. You have to post bond, you have to file an inventory, you have to file a yearly account, and they need authority to expend money before they do that on behalf of the ward. No, a power of attorney is not the same as a guardianship. Under a power of attorney, a competent adult appoints somebody to act as their agent. It could be for healthcare, it could be for finances, or both. The person could give them a broad grant of authority, or they could just authorize a person to act on their behalf for one specific act. It's done without court involvement, and it could be terminated at any time by the person who creates a power of attorney. A guardianship, however, is very different because it only applies to incompetent adults. It is only with court supervision, because the court appoints a guardian. The court could always remove the guardian for cause if need be, and only the court could terminate the guardianship. So they're very, very different. So ideally, people create powers of attorney, hopefully to avoid the need for a guardianship, but that's not always possible. Some examples. For instance, let's say the agent becomes incapacitated or passes away. Or maybe the agent is not acting appropriately, and that would necessitate the need for a guardianship. So even though the idea behind a power of attorney is hopefully prevent the need for a guardianship, sometimes that's not possible. Another thing to also remember is, in order for someone to be appointed guardian, part of the application process that's required is a form has to be filled out by a doctor. It's called a statement of expert evaluation. They need to say in their medical opinion that the person is incompetent, either that they can't care for their activities of daily living or they can't manage their finances. Guardian does not have to be an attorney. Often they're family members, friends of the family. It could be an attorney, but it does not have to be an attorney. It depends. We have people under guardianship for a variety of different things. It could be, if they have severe developmental delays, it could be for their whole life. If the person suffers from a mental health condition and that's something that gets stabilized, then we could terminate that. And the process to terminate it is to file a statement of expert evaluation from a doctor saying that the guardianship is no longer necessary. We would then have a hearing and the guardianship could be terminated at that point. Either if you're a guardian of the person or guardian of the estate, there is reporting requirements every year. So guardian of the person, it's relatively simple. You have to file a guardian's report and guardian's plan. You would also have to file a statement of expert evaluation filled out by a doctor, medical professional, saying that the guardianship needs to be continued. The one caveat about that is if they sign a portion of the report called the guardian's report addendum, then they won't need to file a statement of expert evaluation going forward. But they would always at least need to file a guardian's report and guardian's plan. Now, guardianship of the estate is a little bit more stringent. You have to file accounts every year. You always have to file authority to expend funds prior to spending money for the ward. And at one point, you have to always have filed the inventory as well, 3 months after the appointment. So whenever an application for guardianship is filed, one thing that has to happen is that the proposed ward, the person who would be under guardian, gets personally served by one of our court investigators. They get served with notice of the hearing, when it is, the rights that are afforded to them. Also, that investigator writes a report for the court detailing their observations of the person and whether, in their opinion, a guardianship is necessary and any concerns they may have.